Okay, it is perhaps fitting that we conclude this program with a discussion on chaos. And by that I mean we want to talk a little bit about, one of the basic realities of immigration, which is timing considerations and inefficiencies and a bureaucracy that sometimes gets broken down and a quota system that's very restrictive. So the basic issue that Deborah and I want to discuss, and I think it probably will be discussion, and hopefully involving you as well, is how do you handle one of the inherent complexities of immigration, which is it's a very time-driven, unyielding system that you run into a lot of bumps in the road. So one of the things we want to talk about is how do you deal with it? And maybe to kind of cut in part to cut to the chase, one of the things, and I think this is really important at the beginning of a case, is again going back to this notion of holistically looking at things, trying to come up with expected timelines, looking at family issues. When does a child age out? I mean, that's always kind of on our mind. How much remaining H-1B time or non-immigrant visa status does someone have? And to try to, make sure that those issues are addressed at the very beginning. And then one of the recurrent issues, and I bet a lot of people in this room have faced it, is you have someone who's productively working, and understandably, they want to go back to visit mom and dad back in the home country. And that creates a requirement of applying for a visa, and particularly in the aftermath of 9/11, you have a very rigorous security vetting system at all of the consulates. And very often, that will create significant delays if there's uncertainty in terms of the name clearance process. So what can you do to alleviate that? How do you protect yourself? All of those things Deborah's going to elucidate. Because I have the slightest idea. No, that's not quite true. Okay, so look, one of the things we want to talk about is what are the sources of delays? Okay. One of the things that you've got is the quota system in the United States. And we just want to put this, if you don't have this, it's useful for you to maybe subscribe. You can Google and get the Visa Bulletin. And what that is, that's a publication of the U.S. Department of State. It's sent out electronically, and it gives lots and lots of interesting background information on the quota system. And what this chart does is it tells you, at least for permanent residents, what some of the backlogs are in the quota system. Now, this is a distorted situation for this reason. October 1 starts the new fiscal year. So on October 1, the U.S. immigration system is infused with 140,000 green cards for employment-based purposes. So it's kind of like this flood of numbers. And as a result, you have, it clears up a lot of the backlogs. If we had this chart in September, I kind of wish we had, you would have seen a much different picture. You would have seen a lot of the quota categories exhibiting backlogs. The way to read this chart, and again, the architecture of the quota system is you've got 140,000 numbers divided into 5 preference categories. the very top and the one that's hardest to get into, there are 40,000 green cards, and that's only if you're outstanding or extraordinary or an intercompany manager. Because it is restrictive to get into, relatively few people get into it, the quota doesn't fill, the C means it's current, there's no backlog. Moving down the chart, the second preference is a lower threshold. It says these are for positions of requiring advanced degrees, that is, a master's degree or above. In addition, so there's 40,000 green cards, of which no more than 7% can come from any one country. So what do you have? You've got a big and highly educated population in India or China bumping into the limitation of the 7% rule. As a result, there are backlogs. So, a permanent resident case that will take, a normal perm case will take 18 to 24 months, for example, in the second preference. But if you're from India, it's going to be about a 7-8 year process. So you've got to maintain, your employees' non-immigrant status. It's a lengthy process. It also perhaps suggests that you should start permanent residence for your Indian employees maybe a little bit earlier. The good point is it's somewhat of a retention tool in China. Anyway, you can go down the list. My only point is you have to deal, particularly in the permanent residence, with the quota system. And then that also gets into some of the points that Deborah and I were talking about, which is ways to maybe move up in the preference categories. The EB1, again, for China and India, it becomes quite desirable. So that's kind of the first choke point in terms of starting to come to terms with how long does something take, how do you protect your employee, how do you manage your own expectations in the whole process, okay? Delays. Ms. Schneider.
We're never delayed because you know me, I'm fast. All right. Unfortunately, I only have so much power. We have to deal with the government. They're not fast. So what I pulled up is just 2 examples of what we see for people for like current H-1Bs. So the biggest headache this year has been how long have they been taking this process. And it also depends on where you're located and where the filing is for your H. But you're looking at over a 6-month wait right now for a standard extension. We've seen some go as long as 9 months. For a standard extension, usually similar position, not much has changed. And what does this mean? Well, it means your employee is going to have issues because they're going to need to extend their driver's license. And we have foreign nationals in the U.S. have status checks. So on something simple as just being able to still drive, they're going to need to have a receipt notice and go into the office, and they're going to have to ask to get a 6-month extension and then go back again once it's approved. And if it goes beyond that 6-month window, we're running up to maybe they won't extend it. Certain states like California require approval. They won't do it with an extension. So you have to know the state where your employee is working. So what impacts them? It may impact, what if they have to travel? They can't travel with just a pending petition. So what do? Well, the government solved this by saying, pay us more money, right? So premium processing is $1,225. And in reality of what we do every day, I think it's money well spent. I advise it where possible. I hate to it's not like we want to just throw money to get a job done, but this time a lot of it's worth it because you're going to have security that your employee knows they've been approved, and they're very nervous. They're always nervous to make sure everything is in order. If they have to travel, they have to bring a spouse over, they want to get married, they want to make sure their status is in play. And there may be a strategic reason why you aren't premium processing in certain cases. Maybe they poured into you and you're pretty sure this is a case that may not go over so well. You want to buy some time because you want to, your consultant, you're going to have a better contract in 2 months. There may be strategic reasons. But for most often, you're looking at premium processing.
I think it's become more and more accepted. Just by show of hands, do most people kind of almost as a matter of course for H-1Bs premium process? Does anyone not? My observation is that it's almost become, and it's really too bad, it's almost de facto.
And what's sad is O1s, which has been a big fight. We do a lot of arts cases. So you have to come, you have a performance, you have a date you need to be were supposed to adjudicate these in 2 weeks, but if you look at the filing date, May 30th, they're working on it. You're not going to be able to get people here. So all these, nonprofits and theaters trying to bring over workers are stuck paying these higher fees as well. So it's a very frustrating process. But it's one way to solve a delay when period processing is available. So I think our caveat is use it if you can and you can afford it.
Okay. One of the really unstable aspects occurs when your employees travel, and I mentioned that. Let's just spend a minute more. If someone is already admitted to the United States, they can change status, extend status. All of that is done administratively, okay? But once they leave, then they fall within the jurisdiction of the Department of State, which administers the visa granting process through the consulates. And as I had mentioned, particularly in the aftermath of 9/11, there's an elaborate security apparatus. And so what happens is foreign nationals have to go to the consulate, and almost invariably they have to do a personal appearance. So you can no longer just send in your papers. They have to go up to the window, establish, the fact that they are approved to apply for an H-1B visa or L-1 or whatever the visa is. And then the first thing the consular officer is going to do is figure out, do they match up? Is their intended purpose of coming to the United States consistent with the paperwork they're showing? So it's the H-1B approval notice, the L-1 approval notice. For J's, it's going to be their DS 2019 form, whatever the underlying justification for seeking the visa. There's the initial determination, are they going to do what they say they're going to do? But the second thing, and that we can control. I mean, that, we can create the proper documentation. But then the second element becomes the consular officer runs the name through the name check system. And if there is someone with a similar name with a hit, it can, ultimately, if it can't be cleared up at the consular post, it's going to be sent back to Washington. And it goes through essentially an FBI check. All of that can take time. And in addition, there's a doctrine in the law, and it's called consular absolutism. And what that means is that the consular officer is granted broad discretion to make judgments on issuing visas. And it's not as if you can walk into court and seek due process. So what does this mean? For so much of immigration, I think that we control much of the process. When it comes to the the visa application process, not so much. And so what do you need to do? Number one, I do think that it is wise to have, as a corporate policy, a requirement of notification before someone travels. I think that we very much encourage our individual clients to contact us. Let's talk about the visa application process. Number one, what is required, what you need to prove, what the downsides could be, okay? I mean, and even so, we can only go so far. And when it comes to the security aspect, you just have to kind of wait it out. And some consulates will talk to you, some not. But you also have to kind of understand that you could be facing some type of delay in getting the employee back. So if someone is going, we recommend, as a general rule, they should apply for their visa early in their trip to allow time to work through issues. I mean, that's one thing. If they've got permanent residents going, at some point they're going to get travel permission, advance parole. That would alleviate the need for going to the consulate. So again, things to be concerned about. But the travel issue, it is just a miserable situation.
We call administrative processes a black hole. So when your employee says, I went through, I thought everything looked good, and then they get a letter to say, your case is in administrative processing. You can log on and check, and we'll let you know when your visa is issued. It could be 5 days. It could be 5 months. Not as bad as it once was. I think after 9/11, we were seeing easily 5-6 months of wait for visas. It's even harder when your employees traveling to a third country. So you may need to send your Indian national to China, and then they get admin processing in China, and maybe they only had a 3 visa to be in that country. So you need to really plan ahead strategically, because it'll go up the chain of command to, well, I know the senator, well, I know this. They have no further persuasive authority than you do or we do. If it's had a technology alert list, sometimes you're going to check. If you know you have a high-level scientist, it's probably a good chance you're going to hit a tall hit, and it could take a little longer to clear. So work out timing, and find a way if they can. Can they work remotely when they're traveling? Try to think outside the box of ways to know it could be a month or so till you get them back. So you have someone to cover for them when they're gone. Things you're going to have to watch for. It also becomes problematic, like if you filed a petition and then their positions change. Can you do a quick amended filing? Likely you're going to have to get that approved and then file amended filing. So, working out how long things will take, thinking ahead to what's the job they're going to be in, so we can kind of knowing, it's going to take 6-7 months. Let's file it for this position because this is the one that is going to go down that road. In the interest of efficiency and not to be inefficient, let's move on quick to talk about mistakes. And of course, not lawyer mistakes. Okay? That's why we have insurance. What do we see? A lot of mistakes on name spelling errors. Probably, I think the number one thing is get the receipt notice and someone's name is spelled wrong. That we can fix. Okay, that's often something we can go back to USCIS and correct. Dates of approval. There are mistakes that are made. Either the date you asked for 3 years, they gave you 1, or it isn't matching. Sometimes the officer really meant to shorten the period of time. Maybe they say, we really only think that this is a 1-year approval, or but when you file with premium processing, you actually have a dialogue. Okay, we can contact the unit. If you didn't file with premium processing, it is a long wait to hear back and get things corrected. So another thing to think about. We included requests for evidence and mistakes because I do believe when we file applications, we believe they're approvable or we wouldn't be filing them. So when we get a request for evidence, we don't think it's our mistake. We think it's the government's mistake, right? They didn't look at our evidence properly. But it's when thinking of timing considerations, you have to take in that certain types of petitions are just known for requests for evidence. No matter how well argued, how well documented, this officer may issue a kitchen sink RFP or have one area they want to see additional detail. And you're going to have to think, even with premium processing, we just lost another 15 days plus the time to respond. So we work with tight schedules. You got to just keep that in mind. No matter how well you want things to be done, you have to strategize knowing worst case scenario this could happen. And the ultimate mistake is denying an application. And that's just not allowed to happen. But it can happen. And you may have to go down the appeal route and you have to strategize and think through what are alternatives to keep a person here. And appealing a non-immigrant visa does not give them the right to keep working. It may give them the right to stay here. But we don't have those rights. So we're going to have to think of plan B. What are our other alternatives and strategies? And always kind of keep that in your mindset.
Yeah, also there's one other situation which I think we've probably run into. Someone has, let's say, an approved H-1B petition for 3 years. They travel, they come back, and on re-entering the United States, they're not granted the full 3 years in their status. Oftentimes that's because they have an abbreviated passport, because the law is you're supposed to have a passport valid for the duration of your status plus 6 months. So if your passport is, if your employee's passport is expiring at an early point in time, the CBP inspector, Customs and Border Protection inspector, might admit them for a shorter period of time. Well, how the heck do you know? I mean, as the employer. So again, what we try to do is, and we want to see copies of the visa, copies of the I-94 when they come back. You should be seeking the same thing. But again, it takes two to tango. I mean, you know, the employee has to provide that. But it is something well worth trying to track. And again, it's these travel issues where there's just so many variables. And, you know, from a legal standpoint, you kind of want to say don't travel, but, you know, I never feel right in doing that. I mean, you know, you explain the risks, and but, you know, I'm not in a position, I don't feel I should be in a position to deny someone the right to see, you know, parents and loved ones. Okay, the denouement of the program, which is basically planning ahead. And it simply gets back to what we have recurrently been talking about. And this is kind of the recurrent theme, which is, you know, plan then build. You know, to kind of try to understand, you know, immigration, it seems to me, is so complex in the sense of balancing out and the needs of the employer for stability, predictability, uninterrupted access to employment, understanding the objectives of the employee, trying to fit together things into a puzzle. What we've talked about really over the last 4 hours or so is this wonderful kind of intricate jigsaw puzzle called immigration. There's a lot of moving parts. And to the extent that, you know, you can, you know, address them at, you know, proactively and kind of have plans and fallbacks and so on, you're you know, well advised to do so. So that's kind of, I think, the wrap up in terms of how we at least conceive of delays and pitfalls in the whole process.